There we go. Okay. Are you Larry Whaley?
I am.
Okay. Just so you know, Mr. Whaley, my name is Ron Wagonar. I'm the magistrate here. This is an initial appearance on the new charge that you've been charged with. These are public proceedings, so you can't see it. The media is present on my end over here, just so you know. I try to like to make people aware of that fact. I have an address for you of 116 17th Street Southeast, Apartment 2 in Mason City. Is that your address?
Yes.
Okay.
Yes.
You were originally charged with attempted murder, I believe. That has now been changed, and a new charge has been filed against you. The charge is murder in the first degree under 707.2. Parentheses 1A, which provides a person commits murder in the first degree when a person commits murder under any of the following circumstances. Sub A is a person willfully, deliberately, and with premeditation kills another person. It is alleged that you used a firearm to kill the victim in this case with the initials ST. Do you understand that new charge that you've been charged with?
No, sir.
Okay. I will tell you again what it is. It is that you are charged with having used a firearm to kill the victim in this case. And as I said, first degree murder is where a person commits murder in the first degree when the person commits murder under any of the following circumstances. Person willfully, deliberately, and with premeditation kills another person. In this case, that was ST. Okay? So that is the new charge that you are charged with. This is a Class A felony. It is punishable by up to life in prison without the possibility of parole. Do you understand that?
No, sir.
That means that if you are convicted of this charge, you would be spend your life in prison and you would not be eligible for parole, is what this means. Okay? You have various rights. One is the right to remain silent, not make any admissions or statements about the underlying facts of the case. If you do make any statements or admissions, they can be used against you. So I want you to not make any statements at this time. I want you to remain quiet other than to answer the questions that I ask as to whether or not you understand these. You also have the right to be represented by an attorney and to have an attorney appointed if you cannot afford one. The Public Defender's Office was appointed to represent you in the other case, but because this is a new filing, we need to have you file a new application for counsel in this case. Do you understand that right?
Yes.
Okay. So make sure you file that new application. They will give that to you, and then we will appoint the Public Defender again in this case, just like they were appointed in the other case. Just a minute here. I am scheduling your preliminary hearing in this case. I'm scheduling your preliminary hearing for December 15 at 8:30. That is not trial, that's a preliminary hearing to see if there's enough evidence to proceed with the charge. The county attorney can either put on evidence at the preliminary hearing, or they can file a document called a trial information ahead of that time that sets forth the facts that they are relying on. In most cases, that's what the county attorney will do, is file the trial information. If they do that, then the preliminary hearing will be canceled. So check with your attorney with regard to that. Keep in contact with your attorney to determine whether or not the preliminary hearing will go ahead. After that will be an arraignment date where you'll enter your plea of guilty or not guilty to the district court, and then it'll go on to trial or sentencing, depending on how you plead. Along the way, there will be various court proceedings. Make sure that you show up at all court proceedings along the way in this case. Right now, I am going to hold you on bond. Your bond will be increased under the new charge. It will now be $500,000 cash-only bond, okay? You can ask the district court to reduce the bond amount, but that is the bond amount that I am starting out and setting at this time. Do you have any questions about the bond amount or the preliminary hearing?
No, sir.
Okay. Then do you understand what I have told you with regard to this matter?
Not really, because it wasn't intentional, sir.
Okay. As I said, don't make any statements about your case. Okay. I'm just saying, do you have any questions with regard to the charge or
I was just wondering why it was first degree.
No, okay. As I said, don't make any statements with regard to that. Okay. I am, do you have, at this point then, just get that form filled out, make sure I can tell from that what your income is, okay? And get that form filed with the court, okay? Okay, thank you.